Yes.
Right. And in fact, the majority of times you have testified in court, you generally testify for the defense, correct?
No, the majority of times I've testified in the court, I've been the court's witness.
The court's witness, as a court appointed. But when you testify for either side, the majority of the time you've been hired, you testify for the defense, correct?
Yes.
And currently you're getting paid $250 an hour in this case, correct?
Yes.
Now, you have described to this jury various instances of some of which you categorize as physical abuse done to Ms. Nachtman, correct?
Yes.
And all of that was self-reported by Ms. Nachtman, correct?
I believe all the physical abuse was, yes.
All right. For instance, there were no police reports of any physical abuse?
That's correct.
All right. No DCF reports, no medical records, no witnesses, nothing like that?
Right.
All right. And the same is generally true of the verbal abuse, would you not agree?
Yes.
Now, I want to talk to you specifically about something you said yesterday. You accused Miriam Deans of gaslighting her daughter by showing up to pick her up from school, correct?
Yes.
Now, doctor, you were not there at that time, were you?
No. And I didn't accuse her. I was just relating what was related to and what my opinion was.
You said you believed she was gaslighting her daughter, correct?
Yes.
All right. Just for going to pick her up at school and surprise her, correct?
Oh, it was a little more than that.
Well, she was calling, telling her that Bob was coming to get her up, pick
Yes.
her up, correct? And then she shows up, correct?
Yes.
All right. Now, do you know what Miriam Deans was thinking at that time?
No.
All right. You have no idea if she was just showing up to maybe surprise her at school?
It would seem a little odd to call minutes before you were there and act like you're not there.
Well, have you seen these videos where officers come back from overseas and they surprise their friends and surprise their family members, all these videos that you see on TV? You've seen this, haven't you?
I don't watch that kind of thing, but I know what you mean.
And sometimes when people have been gone for a while or haven't seen each other for a while, they'll surprise them. Would that happen?
I suppose.
Okay. But you don't know, and you're just immediately assuming on behalf of Nicole Nachtman that that's what her intention was, to gaslight her daughter.
Yes, that's my belief that it was.
Right. Now, the opinion of the abuse, and I understand there were other corroborating things you found from testimony from Eric Lear, I believe, and a few other people, as well as some documents from that you encountered. But the majority of the verbal and physical abuse that was described to you by a person who you have described as schizophrenic and who we often know has lied to cover up her actions, correct?
Correct.
Right. She lied to her mom about the bike, correct?
Yes.
She lied to her mom about her grades.
Yes.
She lied to the detective about how long she had been in Tallahassee.
Yes.
She lied to her own uncle about how long she'd been in Tallahassee.
Yes.
She even tried to get her new roommate to lie for her as well, correct?
Yes.
Now, doctor, so again, much of the abuse you've described has come from the words of Nicole Nachtman. Did you ever have a chance to review the text messages, State's Exhibit number 70? Did you ever review these text messages that went between the mother and daughter throughout the year before she was murdered?
Not physically. Yesterday I was in court when you confronted Dr. Heidi with them.
Right. And so this was not a part of your basis of your determination as far as the abuse that Nicole suffered,
That's
correct?
correct.
Doctor, you also mentioned you talked a lot to Eric Lear. Did you ever talk to David Lear?
No.
Right. David Lear was the cousin who had the most contact with him. Did you ever reach out to him or talk to him about what life was like there at the time?
No, I read his statement in his deposition. I didn't talk to him personally.
Now, I'm going to move ahead now to your diagnosis of schizophrenia.
Okay.
So you diagnosed her with schizophrenia. let me ask you, Doctor, do you or do you ever treat people for schizophrenia?
I have
Okay, and what is the standard treatment for schizophrenia?
a combination of psychotropic medications and psychotherapy.
Now, do you prescribe medication?
No.
Now, we've already heard your testimony about your reasoning for schizophrenia. So I'm going to just skip straight ahead to insanity.
Yes.
Now, I'd like to do this in increments if we could.
However you want.
First, have you read the indictment in this case?
I believe I have, yes.
Okay. In the indictment, the thing she's accused of doing is shooting Robert Lear and shooting Miriam Lear.
Among other factors, yes.
The Deans.
Yes.
Deans. Robert Deans and Miriam Deans. So you're aware that that's what she's accused of shooting them. That's what she's accused of doing.
Yes,
Do you
of
agree?
course. Yes.
All right. So the first factor, you already indicated she had a mental infirmity disease.
Yes.
All right. The second factor also has to be proved in order for a person to be found legally insane, correct?
Yes.
All right.
One of those two.
One of these two, either A or B.
Well, no, one of the two in A.
Okay. So she did not know what she was doing or its consequences.
Yes.
All right. Now, based on the indictment in this case, the thing she's alleged to have done is to shoot someone.
Yes.
Now, is it your opinion, doctor, that she did not know at the time she was pulling the trigger that she was shooting Robert Deans?
Yes.
You do not believe she knew she was shooting him?
I believe that she was in a psychotic state. She was suicidal. She didn't know what she was doing.
She had held the gun to herself and was talking about killing herself, correct?
Yes.
And it was right around that time that she decided, no, she wanted to live, correct?
It's hard to say, but it was within a short period of time, yes.
All right. And it was at that time she went and shot Robert Deans.
Yes.
So she knew what a gun could do, correct?
At some level, yes, she did know what a gun could do.
And she knew that if you pull the trigger, a gun could kill you. Because she sure was having it to thinking about killing herself, correct?
She says she was. I'm not sure. She seemed to have been ambivalent about killing herself.
Doctor, do you remember giving a deposition back on July 8th of this month?
Yes.
All right. And do you recall me asking you a question, and this has having to do with whether or not she knew she was shooting Robert Deans? You testified here today that you don't believe she did.
Yeah.
Can I have a page number?
I'm sorry, it's page 79?
And just so the record's clear, it's August 1st.
Oh, no, that's correct. And my question was, and we're talking about this very subject, I mean, because that to me would say that she didn't even know that she didn't know she was shooting a person. It seems to be pretty obvious that she knew that she was shooting someone. And your answer was, I think it was.
Yes.
Right. So you do believe that she didn't know she was shooting someone?
Yes, but she didn't understand that she was killing someone or injuring someone.
All right, well, that leads us to the consequence.
Yes.
Because the doing is the shooting. So you now just said, you do agree she knew what she was doing. She knew she was shooting the gun.
Yes, but she wasn't aware of what the consequences of that would be.
All right, so now let's go to the consequences.
Okay.
Let's discuss the consequences. What are the consequences of shooting someone with a gun?
There are various potential consequences.
Correct. They could be injured,
They
correct?
could be killed.
They could be killed?
They could
Absolutely.
not be injured or killed.
Now, are you stating to this jury that at the time she pulled that trigger, because you already now said she did know she was shooting a gun, that she did not know that she was going to kill or potentially seriously injure Robert Deans?
That's exactly what I'm saying, yes.
What did you think she was doing?
She was in, I don't know what she was doing. She was in a psychotic state. Her reality testing was extremely poor. She had no present capacity to think in rational terms. She was acting irrationally and in a psychotic state.
Well, doctor, didn't she testify that immediately after shooting him, her first thought was, oh my gosh, the police are gonna come, that was so loud?
Did she testify to that? I don't know.
Did she talk to you about that? Did she
Yes.
talk to you all about
Yes,
that?
yeah, after the fact, yes.
Yes. So right after shooting him, she immediately knew the police were coming.
Well, she
Or
didn't,
believed the police were coming.
she didn't say right after. She said at some point after she believed that, oh my gosh, this was loud, police may be called. I'd agree to that.
So Robert Deans is dead,
Yes.
and she now starts cleaning up, correct?
I don't know whether she started immediately, but sometime between the two killings, she did make efforts to clean up.
Okay. And she moves his body into another room, she locks him in that room, correct?
I don't know about the locking, but she moved him to another room.
All right. And the next day comes, no police have shown up,
Right?
and at this point in time, she gets the word of the housing, correct?
She gets what?
Word that she's got housing,
Yes.
all right? And she fills out all the proper paperwork for the housing.
I don't know when that was filled out. My understanding is that she had applied late, and
All right.
so I don't know if that was, the paperwork was filled out that day or days earlier or months earlier.
So you haven't seen the records of her, from her phone where she scanned in and sent a housing contract to?
I did not see that.
Okay, well, she did, so so beyond that, she also had to get the money for the housing, correct?
I'm aware of that,
And
yes.
she went and saw David Lear and got the money for the housing,
Yes,
correct?
she did.
She knew what she was doing, getting all this stuff so she could get her housing done, correct?
Yes.
Alright. And then, she knows her mom's coming home, correct?
Correct. Well, she doesn't know when, but
But she knows she's coming
she
home.
eventually, yes.
And so she goes and hides her car.
I don't know if I'd say hide it. She parked it around the corner.
Showing you State's Exhibit number 67. Just so you're aware, Doctor. This is the location of the home. The vehicle, based on GPS coordinates when her mom got home, was parked approximately 1.7 miles away. You were not aware of that?
No, that's not consistent with what you told me.
So it's not consistent with what she told you, but the evidence has shown that the GPS in the car was parked 1.7 miles.
Well, I mean, you're showing me a map. I have no idea of the truth of what you just showed me.
Because you're relying on what Nicole Nachtman told you.
No, I'm happy to rely upon what you tell me as an officer of the court. If you tell me that the car was parked 1.7 miles away, I said that's inconsistent with what you told me.
Okay. So then she stays at the home when this mother, who she's so deathly afraid of, is coming home, correct?
She stayed, yes.
And she parked her car away so that her mom would not see it and her mom would not know she was home,
Well,
correct?
I don't know who parked the car. I assume she parked the car.
Okay. Either way, the car got parked away so that her mom would not see that she was there, correct?
Yes.
So when her mother gets home, she jumps out the window
Yes.
apparently to escape at that time,
Yes.
all right? Or at that moment in time, she runs into her mother, correct?
Yes.
She still has the gun in her hand, correct?
Yes.
And we've already established that she knows how to shoot the gun, and she knows what shooting a gun is. So she knows, again, when we go into Miriam Deans,
Mm-hmm.
she
Yes.
knows what she was doing, shooting a gun when she eventually shot her mother, correct?
Again, I don't believe she knew what she was doing. She was in a psychotic state.
Doctor, I think you're expanding doing. Doing means the physical act of shooting a gun. Are you saying she
Objection,
did?
that's counsel's interpretation of the law, that's not what the jury instruction says. We can approach.
Approach.
So, Doctor, it's your opinion then today, you're telling this jury that Nicole Nachtman did not know she was shooting a gun.
She did not.
Doctor, what do you think she thought she was doing? Blowing bubbles?
She wasn't blowing bubbles. I mean, that's a rather demeaning statement, don't you
Well,
think,
Doctor,
counsel?
you're saying she doesn't know she was shooting a gun. What does she think she was doing at that moment?
She was in a state of panic. She was in a psychotic state. She was suicidal, and she had a gun in her hand. She can't even tell you what she was doing.
Okay. Well, Doctor, based on her actions, after she shot her mother, she ran, correct?
Yes,
She ran to her car, correct?
eventually, yes,
And then she left
Yes.
to Tallahassee, correct?
yes.
And so she very well knew that police were coming, did she not?
She had an idea at that point, after the fact, yes.
Because she knew she had done something wrong,
She saw it.
and she knew the consequences of doing something wrong was that she was going to go to jail.
No, I don't think she knew that. She never said anything about going to jail. In fact, months later, she's still talking about being banished from the state or being on probation. She was afraid that the police were going to come. I agree with that.
Doctor, do you, I know you've seen some of the evidence in this case, correct?
Yes,
And you heard from, or seen at least the transcript of her conversation with her brother.
yes,
And in that transcript, she tells her brother, very first thing she says to him is, "I'm going to miss you, Joey."
yes,
Do you remember that?
yes,
She also, when she goes and gets the money from David Lear, she gives him a big hug because she doesn't know when she's going to see him again.
yes,
And she also tells her best friend, "You've been a good friend." to me."
yes.
She knew it was wrong to kill her parents, correct?
I would say that there is evidence after the fact that could lead some people to conclude that. I don't have an opinion about, that's B prong, whether she knew it was wrong or not. I will acknowledge that she left the scene, she lied to people, she engaged in other behavior that suggests that she knew at that point that it was wrong. But you know as well as I do, what we need to focus on is the instant in which she killed her mother, the instant in which she killed her stepfather. What happens after may help us understand that, but it's certainly not dispositive.
Well, doctor, she also admitted to another psychiatrist or another doctor that she, in fact, knew it was wrong to kill her parents, didn't she?
Yeah, Dr. Lazarou said, "Did you know it was wrong?" And she said, "Yes."
I have a moment, Judge. Go past, please.
Redirect.
Dr. Ewing, you just stated that in fact, and I think we went over it earlier, but let's review the first sentence of this insanity instruction that is on your screen.
An issue in this case is whether Nicole Nachtman was insane when the crime allegedly was committed.
Is anywhere in this instruction, as far as you know, indicate that an individual's actions after the crime need to be considered?
No.
Does the fact that Nicole Nachtman parked her car, whether it was down the street or 1.7 miles away, change your opinion as to whether at the time she killed Robert Deans and Miriam Deans, she was suffering from a mental infirmity, disease, or defect, and that because of that condition, she did not know what she was doing or its consequences?
Doesn't change my opinion at all.
Let's first start with Robert Deans. You mentioned on cross-examination to Mr. Terry, when he asked you about whether she knew she was shooting a gun and what that meant, and that meant it was going to kill somebody. What is going on in the mind of Nicole Nachtman based on what she relayed to you, based on your review of the materials and what you know to be true about Nicole Nachtman? What was going through her mind at the time Robert Deans was killed?
She was confused, she was panicked, she was suicidal, she was ambivalent, she was in a state of psychosis in which she was not acting or thinking rationally. And as a result, she shot and killed this poor man.
Now, you had indicated, or you were asked on cross-examination about the police documents, and there is evidence to suggest that the scene may have been cleaned up after the killing of Robert Deans. Is that correct?
Yes.
Does that in any way change your opinion as to what she was thinking and what was in her mind at the time she pulled the trigger and killed Robert Deans?
No, I considered it. I gave it a lot of consideration because the normal thing to do if you know you've done something wrong is try to flee or try to escape. She didn't. She stayed there. She left. She even came back. Whether she cleaned up or not, it doesn't matter to me.
What is the evidence as far as the records you reviewed as far as Robert Deans' time of death and when Miriam Deans is shot, and how long Nicole Nachtman stayed in that home with a decomposing body?
A couple of days.
What is your opinion as to, at the time Miriam Deans arrives at the house and Nicole Nachtman jumps out her bedroom window and is confronted by Miss Deans in the driveway, what is your opinion as to what is going through the mind of Nicole Nachtman at the time she pulls the trigger and kills her mother?
She's still psychotic. She's confused, ambivalent, suicidal, fearful. She feared that her mother would kill her. At the same time, she was still pondering whether to kill herself.
Is part of your opinion as to schizophrenia and the delusional beliefs that Nicole Nachtman was experiencing that in her mind she really believed her mother was going to kill her at that moment?
She did, absolutely.
And the reason you've characterized that as a delusion is because it's a fixed belief that nobody can shake from Nicole Nachtman even as we speak in 2019.
That's right.
I don't have any other questions. Thank you, Dr. Ewing.
Thank you.
Doctor, you may step down.
Thank you, Your Honor.
May he be excused by the defense?
Judge, if we could approve.
Yes. Ladies and gentlemen, we're going to take a short break. There are some things I have to discuss with the attorneys before we decide what we're going to do next. So I'm going to go ahead and give you a break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid any exposure to the case outside of the courtroom. All rise for the jury.
Oh, okay.
Jury has exited. Everyone may be seated. My intent was to do the colloquy with her.
Okay.
I don't know what she's
You were
gonna
sending
decide.
him to lunch and time for all of that, or, I'm sorry,
No, I mean,
I misunderstood.
if you had another witness, then I was going to keep them around and do a later lunch. But if you're not prepared, because part of my colloquy with her is if she's had enough time.
She has, Judge, I just want to confirm nothing's changed since the last time we spoke. Judge, she's prepared for the call.
All right, Ms. Nachtman, I need to ask you some questions, so if I could please have you stand. I am going to need to swear you in. These questions will be under oath. If you'll raise your right hand, please, thank you. Do you swear any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. Put your hand down. Ma'am, this is the point. Let me just verify with the attorneys. There are no other possible witnesses at this time besides the possibility of her testifying. Is that correct?
Yes.
All right, and so the next thing for the defense to do would be to rest if she doesn't testify. Is that correct?
And when would you want us to do the proffer?
Which proffer?
Before we rest of Mr. Nachtman.
Oh,
When would you like us to do the proffer, before or after we rest, just so the
I don't
record's
think
clear?
it matters. Well, I mean, if you have if there's a legal reason to do it before you rest, I'm willing to do it before you rest.
There isn't, Judge.
All right, then let's do it after, because part of this is if I determine that I just don't know yet. Let me get through with her, because you all may be in a position to rest, and then I send the jury to lunch. Ms. Nachtman, you have an absolute right to remain silent and not testify during this trial. If you do that, I will instruct the jury that you exercised a fundamental right and they are not to hold that against you. In fact, that instruction has already been included in a preliminary instruction that they heard, but I am letting you know that it is also in a final instruction, that they are not to consider the fact that you did or you did not testify. The other side of that is that you have an absolute right to come down here to take this stand, to be sworn in front of the jury, and to testify in your case. That is your decision and your decision alone. Nobody should change your mind on that decision if that is what you want to do. Now, I do suggest that you discuss that decision with your attorneys and you take their advice into consideration. But I want you to understand that at the end, it is your decision. Do you understand that?
Yes.
All right. Have you had sufficient time to discuss your decision, whether to testify or not testify in your case with your attorneys?
Yes.
Have you made a decision?
Yes.
What is your decision?
No.
You do not want to testify, is that correct?
Yes.
All right. Has anyone forced you or threatened you in any way to get you to reach this decision not to testify?
No.
Are you under the influence of any drugs, alcohol, or medication that may affect your ability to reach this decision?
No.
All right. I'm going to accept that. Now, I will let you know that if for some reason you change your mind, up until the point that the defense announces in front of the jury that they rest, You have that ability. I accept that you have expressed to me your decision and that you've reached that decision freely and voluntarily not to testify. But if for any reason you change your mind before the defense rests, I'm going to ask that you let your attorneys know, and I'll ask the attorneys to ask to approach, and we can do that. But at this point, thank you, Ms. Nachtman, you may be seated. I'm going to accept that colloquy as her decision and that it's been freely and voluntarily reached not to testify. So, it sounds like then...
Yes, we would be in a position to rest.
All right. So what I'd like to do is bring them in, let you rest, and then send them to lunch. And then we can discuss, I'm sure there's going to be some motions from the defense. We can discuss any other things. So how long should I give them?
Judge, I was just only going to suggest, if possible, the defense has given us their JOA case law now for the second JOA.
Right.
I have a preference, if possible, to do that now and attempt to do David Lear before they go to lunch. He is a very brief witness, and I think it would be helpful from both sides to ensure that after that, there is no rebuttal based on that. They already know, we already know the testimony of Dr. Lazaro, so that's not necessarily going to change, I don't think. But, I mean, he's a very brief witness.
Okay. I mean, it's only 11:30. I'm not against that. We've sent them to lunch. We've sent them to lunch at 12:30 before.
Judge, the judgment of acquittal argument as to self-defense is not going to be long.
That was my thought.
All right. So, how about this then? How about if you officially rest now, and then I will allow you to ceremoniously rest in front of them, so that we don't need to bring them back in, send them out, and do our legal argument. Is that all right?
That's fine. If we want to go right into David Lear, understanding that I am not waiving my right to argue judgment of acquittal at the close of my case, we're just doing it for timing.
Oh, I don't think they do it now.
No, yeah, do the
Oh,
argument
judgment
now.
of acquittal now.
Go ahead and, but you need to
You're throwing me
rest.
off. I'm sorry. Yes.
I will allow you to rest in front of the jury, but you're officially, legally resting now, and
Yes,
we
sir.
go into your argument.
So
I got you now.
the defense rests at this time,
All right, thank you.
pursuant to the discussion we just had a minute ago.
Thank you,
Sorry.
Ms. Holt. It's all right, no need to apologize.
Judge, I cited and provided the court and the state 3 cases.
Let me find them. Is that Jefferson versus State?
Stee would be the first, or Stay, Jefferson and Martin.
Right, Stieh, Martin, and Jefferson. I got them.
Judge, the Stay case is the second DCA case. It's 67 Southern 3rd 275. If you go to head note 7 on page 2, self-defense cases are intensely fact-specific, but where the evidence leaves room for 2 or more inferences of fact, at least one of which is consistent with the defendant's hypothesis of innocence, it is not legally sufficient to make a case for the jury. And Judge, I want to go back to the case that I cited earlier in the week.
Martin?
It's a different Martin, and so I want to put that side on the... I know it's confusing, but this Martin I gave you is not that Martin.
Well, that Martin is the one that got you the ability to argue self-defense because of the delusions.
Correct. And let me get that one, I'm sorry. And
There's
the reason I
another
want to
Martin?
bring that up is because I believe that those facts of self-defense and insanity are analogous to our case.
Well, the one I have is the one with the police who approached Mr.
That's
Martin.
the one.
Okay.
I just want to put the case site so it's not confusing, because we have 2 Martins.
Okay, at this point, I'm not aware of any other Martin than the one that it appears that we're talking about with the police officers.
Well,
and
no,
the
you have
delusions.
Martin in front of you that I gave you for self-defense. That's 2018 Florida App Lexus 6190. Martin v. State that allowed insanity in self-defense is 110 Southern 3rd 936. There's
Okay.
2 Martins. That's why I didn't want to be confused.
All right.
The Martin that the court relied on in granting our self-defense instruction is 110 Southern 3rd 936. And as I argued earlier in the week, I believe the facts of this case are very, very similar, if not exact, to ours in the sense of the defense was asserting insanity and self-defense, and that this case stood for the proposition that if there was any evidence that tends in any way, even directly or indirectly, to establish a reasonable doubt of a defendant's guilt, that the instruction should be given. And what the court said in this case is that insanity and self-defense are not inconsistent defenses, and that particularly in this case, because the appellant, due to his mental illness and due to the fact that he was delirious or possibly insane, that he believed that in this case police officers were going to kill him, therefore it was appropriate to instruct the jury on self-defense. I bring that up because I believe that those facts in the court granting the self-defense instruction and indicating that insanity and self-defense can both be argued, that applies to our case. With regard to the motion for judgment of acquittal, when you go back to stay, which is S-T-I-E-H for the record, 67 Southern 3rd 275, you go on to page 3, that indicates the facts that were presented with regard to the stature of the victim in this case. The defendant was 5 feet 5, 130 pounds. The victim was 5 feet 7, 160 pounds. It was uncontested that the victim was demeaning, demanding, and aggressive during the encounter. The defense presented testimony of several witnesses to testify to the victim's demeanor in this case. The victim was screaming that he was going to kill both the defendant and a witness who testified. And in that case, the court, on page 4 of the opinion, indicated that the denial of a motion for judgment of acquittal is under a de novo standard, although the question of whether a defendant acted in justifiable self-defense is generally a question for the jury. When the defense presents a prima facie case of self-defense, the state has the burden to prove beyond a reasonable doubt that the defendant did not act in self-defense. However, if the state fails to sustain this burden of proof, the trial court is duty-bound to grant a judgment of acquittal in favor of the defendant. And so now that we have elicited testimony on both insanity, Nicole Nachtman's state of mind at the time she shot, more specifically her mother, but also her state of mind as it relates to Bob, the fact that we've presented now abuse history, an opinion on battered child syndrome, the facts, as I argued earlier this week for the self-defense instruction. We have Dr. Krastowski testifying to the close-range firing when Miriam Deans is shot. We have testimony with regard to Miriam Deans' height and weight at autopsy, that this in fact was close range, and even the 2 gunshots that were not close range, all Dr. Krastowski could say is that it's possibly that the shooter was, or the muzzle of the gun was more than 2 feet away from Ms. Deans when she was shot. Based on the totality of everything the court's heard at this point, our mental health evidence, evidence of battered child syndrome, the encounter, the jumping out the bedroom window, and encountering her mother in the driveway, we're asking the court to grant our judgment of acquittal on self-defense as it relates to Miriam Deans.
Do you have any other judgment of acquittal arguments at this time?
No.
All right. State.
Yes, Judge, just briefly.
I'm sorry, I'll renew my
Right.
argument as to premeditation from the first judgment of acquittal, because
In order to preserve it, absolutely.
all of that still applies, but this is just additional now that we've rested.
All right.
As to the second count only regarding Miriam Deans, the state would ask you to deny the motion for judgment of acquittal at this time. The Martin case that Ms. Hersey has provided, the first Martin case from the first district from 2013, the state would point out that that deals with the trial court failing to give the self-defense instruction. That doesn't have any holding in it as to an improper denial of a motion for judgment of acquittal. It specifically deals with that should have been given. So that's distinguishable as to this issue. As to Ms. Hersey's argument that they presented a prima facie case of self-defense, the state would disagree with that. Their own doctors have said that the defendant had absolutely no reasonable basis to believe that her mother was going to kill her. Rather, it was purely a delusion. So while I agree they presented evidence as to insanity, that is a question for the jury, and it's not a reasonable belief as to self-defense. The 3 cases that she has presented, Jefferson, Martin, and Stay, regarding self-defense are all essentially stand your ground type cases where there was extreme evidence that the victim had previously threatened the defendant, the victim had charged into his house, the victim had a knife, victim was very angry. You know, there's a lot of evidence in those cases.
None of them are based on delusion.
Correct, Judge. So based on that, they're very distinguishable from our facts, and this is a case that should go to the jury. The factual circumstances here, we would ask you to deny the motion.
Anything else from the defense?
No, sir.
I'm going to deny the motion. So what we're gonna do from a timing perspective is bring them in, allow you to rest. The state is requesting rebuttal evidence. Do you have any objection to the rebuttal witnesses?
Judge, our objection is not to Dr. Lazaro.
Right.
However, our objection to Mr. Lear and the one photograph we lodged an objection to, a photograph of Miss Nachtman with her cousin David in high school is not relevant to whether she was an abused child, what her relationship was like with her mother, or any of the issues that we've heard in this case. So our objection as to that one photograph is relevant.
All right, I'm going to overrule that objection as to relevance. There's been testimony from them that she changed at some point, and that point includes the time frame that the picture seems to address. So I'm going to overrule the relevance objection. So other than that, the state is absolutely entitled to present a rebuttal case, particularly the Dr. Lazaro, who is present. But I don't think we're not going to get to her before lunch. It sounds like from a timing perspective, it's 11:45. I'm going to bring them in. I'm going to allow you to ceremoniously rest in front of them. Then I'll turn to the state and ask if they have a rebuttal case and ask you to call your first witness. We'll get that witness on and off, and I'll send them to lunch. Let me just see. So if we get them to lunch at 12 and I give them an hour, we come back at 1. I suppose that there's a chance we can get to closing arguments today. Let's
It
do
can't be
that.
an hour from now?
What's that? No, an hour from whenever we finish with their first rebuttal witness.
Oh, okay.
If we get them, if I release them at 12, tell them to come back
Yes,
at
I forgot
1,
about David.
and we get Dr. Lazaro on the stand at 1.
I'm gonna stop talking, Judge.
Thank you, Ms. Holt. Let's bring it. State ready?
Yes, Judge.
Defense ready?
Yes.
Let's bring in the jury.
I think I'm delirious.
Yeah.
And let me just say, you know, I said that I'm opposed to sending them out at or after 5 because I'm concerned about them and then being here a long time. I have no objection to asking them what we've done that before too. So
Judge,
even
what
if
I
we,
would propose is closings if we can,
Right.
time-wise, and not instructing them until first thing in the morning and then sending them back. I think the law is
Okay.
important, and so instructing them on not to formulate opinions and all
Right.
that before they
but
leave.
bring them in the morning, read them
If
the.
we get there time-wise,
Okay.
that would be my preference.
Okay, well, and it seems like the state's agreeing, and I have always said, when the two parties agree, who am I to stand in the way of progress? That sounds like a good plan for me.
Ready, Judge?
Yes, we are.
All right, jury entering.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Did anyone discuss the case, do any research related to the case, or was anyone exposed to any reports about the case during the most recent break? By show of hands. No hands, thank you very much. I'm now going to ask the defense if they are ready to proceed.
The defense rests at this time, Your Honor.
All right, defense having rested, we now turn to the state to see if they have a rebuttal case.
Yes, Judge. David Lear.
All right, your first witness in the rebuttal case is David Lear. Mr. Lear, welcome back, sir. If you'll come forward, I will swear you in again. Wherever you're comfortable, if you'll face me and raise your right hand, thank you. Do you swear any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. If you'll come on back down to the witness stand, please watch your step. Go ahead and have a seat in the chair and make yourself comfortable.
Good morning, Mr. Lear.
Hey, good morning.
Mr. Lear, you provided the state some photographs that you had in this case, did you not?
Yes, I did.
All right, I'm going to show you what are marked as State's Exhibit 73A and B. photos?
Oh yes, I do.
And what are they photos of?
One is a convention in Orlando, back in 2012. Me and my family and Nicole, with the actor from The Walking Dead.
Okay.
The second one is 3 photos of my aunt and my cousins and Nicole in Texas.
All right, do those pictures fairly and accurately depict those circumstances that you just described?
Yes.
Judge, move to have State's Exhibit 73A be admitted into
Other
evidence.
than what was discussed, any objections at the time?
Not other than what was already discussed.
They'll be admitted.
All right, move to publish, Your Honor.
You may publish.
In the picture at the top, who are the people in that picture? I assume Nicole Nachtman?
Yeah, Nicole Nachtman is the girl with the white shirt. Her older brother, Joseph Carey, with no shirt on. Her older brother, Kevin Carey, with the red shirt on,
Okay.
with the pets.
In the picture below that, who are those two people?
That is Nicole as the baby. Her mother, Miriam.
All right. And the picture below that?
Also Miriam and Nicole.
All right. And then in 73B, who do we have in that picture?
This is at a convention in Orlando.
What was the convention?
What was the convention?
Yeah, do you recall?
It was like a horror convention or a Comic-Con convention.
Okay.
Yeah.
And who do we see in this picture?
I'm in the picture with a hat on, with the long hair. That's my oldest son, 21 years old. His name is Justin Lair. The boy with the red shirt on is my son, Benjamin Lair. The infant baby is my son, Kevin Lair. Nicole Nachtman with the Freddy Krueger outfit on, and one of the actors from Walking Dead.
Okay. And how old was Nicole Nachtman in this picture? Do you recall?
2012. I guess that would make her about 17 or 18, 19.
Right. And do you recall what year in school she was at that point?
I think high school. Yeah, senior high school.
Did she need to get permission from her mom to come to this? Do you recall?
Objection to speculation?
She did.
I'm going to sustain.
Right. How did she go to the convention with you?
Objection based on hearsay?
No. She does.
Approach.
Did she?
No.
And did she ride with you to the convention?
Yes, she did.
No further questions before this judge.
Any cross-examination?
Yes, sir. Good morning, Mr. Lear.
Hi, good morning.
State's Exhibit 73A. How old is Nicole in the second photograph in the middle and the bottom photograph?
She is about a year old or just over a year old.
And that would have been when they lived in Texas?
Yes.
And you weren't in Texas with them for these pictures, correct?
Not for the pictures, no.
Okay. And then how old do you think Nicole is in photograph 1 where she's with Joey and Kevin?
About 2.5 to 3 years old.
Okay. So nothing over 2.5 or 3 years old as far as these 3 pictures. Everything is about that toddler age, 1, 2, or 3.
Yes, ma'am.
State's Exhibit 73B. Just for the jury's benefit, Comic-Con, is that like a convention where people go dressed in costume?
Yes.
Okay. I don't have any other questions.
Any redirect?
No, Your Honor.
May this witness be excused?
You may, Your Honor.
And by the defense? Excused?
Yes.
All right, Mr. Lear, you may step down. You may be excused as a witness at this time.
Okay, thank you.
Actually, if I can have you stand right here, I'm going to go ahead and dismiss the jury for lunch. Ladies and gentlemen, it is almost 12 o'clock. It's 7 minutes till 12. I'm going to give you then a little bit over an hour. I'm asking you to come back at 1 o'clock. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid any reports of the case outside of the courtroom. All rise for the jury. Jury has exited. Everyone may be seated, and you may step down, Mr. Terry.
Thank you.
Judge, for the record purposes, I'm gonna introduce the video evaluations that the court did not allow in as a court exhibit 4 that will not go back to the jury.
These are the video evaluations conducted by Dr. Lazaro?
Lazaro, yes, just as a court exhibit for the appellate court.
Absolutely. And
And
what
then-
number was it? It's not the
It's
first.
court exhibit 4.
Okay.
And then, Judge, we have the proffered testimony. It's
Oh.
very brief of Ronald Nachtman. He wants to sit in the courtroom for the rest of the trial, but I just rather get that done. And
Yes.
it's brief about
Any-
the abuse
any
related
problem?
to.
No,
the
I
child.
agree, I'd like to do it now.
Absolutely.
To eliminate that.
Absolutely. Let's get him in. And then he can be released, and then he can sit in the
Correct.
courtroom.
Yes.
Yeah, I mean, it's fine, I just, if we need to change it, but that's fine.
And Judge, so the record's clear, we wanted to ask Mr. Nachtman about abuse that Nicole Nachtman suffered when she was an infant, when he was holding her and Miriam Deans was violent. The court excluded that in the testimony, I believe, based on the argument by the state that she's a baby, it's obviously not gonna affect her. And now we've had expert testimony or that, in fact, that tumultuous time in her life was crucial. So for the record purposes, I just wanna proffer what he would have said
Right.
about those
Uh,
tender years.
He's welcome. Mr. Nachtman, welcome back. You come on down to the witness stand. They're going to conduct a proffer outside the presence of the jury, so I'm going to have to swear you in. You can come on down.
Yes, sir, thank you.
If you'll raise your right hand, please. Thank you. Do you swear any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can come on down. And also, we're doing it now so that then you can remain in the courtroom. You can be released and remain in the courtroom from this point forward.
Thank you very much, sir.
Mr. Nachtman, tell us your name.
Ronald Gene Nachtman.
And you've already testified in this trial. You're Nicole's father, correct? Biological father.
Yes, ma'am.
I want to ask you some questions that we were not able to ask you earlier this week in front of the jury, just for the record.
Yes, sir. Yes, ma'am.
Can you tell me at what point Miriam Dean started to become violent with you?
It was August 7th of 1993. It was a weekend that the boys weren't there. They had arrived on August 1st.
Was Nicole born yet?
No, ma'am.
Was Miriam pregnant with Nicole at the time?
Yes, ma'am.
Okay. Please just relay instances of where Miriam Deans would have either become physically abusive towards you or violent to you, and describe those instances.
On August 7th, it was Saturday. She said, let's go play some golf. And I said, well, let's go this afternoon. And she said, well, I'm going to get some golf in early this morning. I said, okay, I'll get some breakfast. I went to the kitchen. And she started screaming, I'm tired of your abuse. And she picked up a suitcase. I just got back from a business meeting. It was left near a box that she left for a month. And she started screaming, I'm tired of your abuse. And I said, well, we're not going to play golf? She said, no. So I walked over from the kitchen into the dining room, which is dining and living room this area. And she was at the front door screaming, I'm tired of your abuse. And she was throwing my clothes out the front door.
Had you in any way been violent or hit or struck Miriam Deans at this point?
No, ma'am, there was really no problems at that.
So tell me what physically she did to you in terms of touching you or hitting you.
Well, I said, why are you doing this? And she turned around at the front door, throwing the clothes out, and she came towards me, and she got me on the neck, and she started suffocating me.
You have your hands holding your neck.
I had her hands, both hands on my neck, and she was suffocating me.
And at the time of this incident in 1993, Miriam was how far along pregnant with Nicole?
She was about 4 months, ma'am.
Are there any other instances where Miriam Deans was either violent or abusive towards you?
Yes, ma'am, on September 5th.
Of that same year?
Yes.
Okay.
Yeah. We had about 17 of these. We were sitting there by the love seat, double love seat. She had a big brass newspaper rack, and she said, hand me the TV section. I said, it's right there. She stood up. She said, I'm tired of your abuse, she screamed. I'm tired of your abuse. And she picked up the newspaper rack, and she rammed it on my right arm, but it moved back to the thing, the seat, and then she started ripping the newspaper up. I'm tired of your abuse. And I just left.
And she was pregnant, 5 months or so pregnant with Nicole at that point?
That was September 5th, ma'am, yes.
What other instances where Miriam Dean became violent, either in Nicole's presence or while she was pregnant with Nicole?
Well, on the 15th
Of what month?
of September
Of what year?
1993,
Okay.
this was the last one. This was the last one. The night before, she said, "I'm gonna put some laundry in the washing machine and the dryer."
Just tell me what happened without telling me what Miriam.
Well, at the
said.
front door, she accosted me and said, "You took the laundry in the wash?" And I said, "No, no." And she started shoving me. I walked to the back of the house, and I said, She kept screaming, "You abused me! You abused me!" And I said, "Well, maybe one of your boys took the laundry out." And right then, she started punching me in the face. She got me one time in the face. My head went back. And she punched me again in the face, and my head went back. And I was holding my head. I said, "Why are you doing this?" And then she started grabbing my nipples and trying to yank my nipples out. And I got out of there.
Were there instances where after Nicole was born, where you would be holding Nicole and Miriam Deans would become violent with you?
Yes, ma'am. They
Tell me
started.
about those.
They started in May. She agreed I could take Nicole back right
Hold on
before.
1 second, Ronald.
Yes,
Mr. Nachtman, I'm sorry.
that's fine.
How old was Nicole during this incident?
The first instance, she was 3 months old.
3 months old. And what were you doing? What did Miriam Deans do to you as you were holding Nicole?
She started shoving me and Nicole against the wall violently.
Did you receive any injury? Did Nicole receive any injury?
No, I just told her to stop it. She left.
What other instances in front of Nicole or after Nicole was born where Miriam was violent with you?
Then in May, she did the same thing. I took Nicole home for a week to Cincinnati. She came over again right before the trip and started violently shoving Nicole and I against the wall. And then the third one was October 16th. Now, in September 11th, she asked me to bring Nicole over to work. And it was a Sunday. Whenever there, she wasn't at work. So I took Nicole every day with our baby jogger to the park.
Just
And
tell me what happened between you and Miss Deans, Mr.
She
Nachtman.
drove the car up. She ran out of the car screaming, "You're denying me my baby." And I'm holding Nicole, and she starts punching me in the head by the orbit here. She punched me 3 times. She knocked me and Nicole to the ground.
Were there any other instances where Miriam Deans was violent with you or abusive towards you after Nicole Nachtman's birth?
So we had incidences in November 11th and in December 6th.
And how old would Nicole have been during that time?
Well, September 11th, she was about 8 months when I was holding Nicole and she fractured my skull.
Okay.
So October, she would have been 9 months old. When
Any
that,
other instances you can think of as you sit here today after Nicole's birth where Miriam was either abusive or physical?
well, up to the time where I had her living with me every day, she was coming over to the apartment. That's when she was physically abusive. On November 11th, she picked her up for the day, took her to Clear Lake. She called me to come down and get her. She grabbed me in the apartment and started kicking me. And she was screaming that I was abusing her. And then Joey called the police. And
So the police were called in certain instances of turmoil between you and Miriam after Nicole was born.
I wasn't in turmoil. She just told me to come down and get Nicole.
My question was, were police called during these, or any of these instances after Nicole was born or while Miriam was pregnant with Nicole?
Yeah.
About how many times do you think police were called?
I kept track. I was living. We had like 29 instances at 12 at my place and 17 at her place. Where at her place, 17 times Joey called the police. She would get me into the apartment and start.
How old was Nicole during the last incident of abuse or violence between you and Miriam?
She said she picked her up on Monday.
How old was Nicole for the last
2 years and I think 10 months. It was October 6th.
I don't have any other questions. Thank you, Mr. Nachtman.
Any cross-examination?
No, sir, not for the proffer, no, sir.
All right, thank you very much, sir. You may step down.
Thank you, sir.
And he can remain in the courtroom for the rest of the trial, Judge?
I believe so. Is there any objection from the state?
No, sir, not as long as the court's prior ruling hasn't changed and you know, he's.
Well,
correct. So
I was gonna ask, go ahead, sir, if you'll step out, you can step down, go ahead and step outside.
You want me to leave the courtroom?
Just briefly, we're gonna go to lunch in a minute anyway. The
Okay.
issue we're gonna discuss is whether you can remain in the courtroom for the rest of the proceedings, which I believe you're going to, but if you'll step outside at this time briefly, and then we're gonna break for lunch.
Okay.
We'll let you know, Robert.
I just wanted to ask the state if you've changed your mind as to let him testify.
No, sir, we have not changed our mind, and I would put on the record that I listened closely to the doctor's testimony, and I don't believe that the defense doctors clearly said that based on activity that occurred when Nicole was in the womb, that while I agree that they said very young, as a very young child, you know, that she lived in a tumultuous household, and, you know, that there was conflict between the parties, I agree.
And they've heard testimony about
Right, I
that.
agree that all that came out, and I agree that he testified to that he actually, over our objection, you know, said to the jury that she beat him repeatedly in the head. So, that's come out, but, I don't.
Well, what about that's, okay, we gotta separate it though.
Yeah.
There's the one where she was pregnant, the August, I think, dates that he mentioned, 7th and September 5th dates perhaps. But he did testify to some incidents where he was holding her.
Right, no, I totally am aware of that, Judge, and the state's position is the same. I don't think that based on the defense expert's testimony, I think that, again, they said in general that they did consider overall tumultuous childhood and all of that sort of thing, but I think that his specific statements that Miriam Deans beat him or hit him when he was holding the child, the prejudicial effect of that far outweighs the probative value, which is that she had a tumultuous childhood, which has been testified to. So no, our position is exactly the same. I don't believe that he should be permitted to testify to that.
All right, let me just verify with the defense, you still want the ability to call him?
Yes, sir.
I'm gonna maintain my prior ruling, based on the state's argument and my recollection of the expert's testimony. So, you've got your proffer on the record for appellate purposes.
Thank you, Judge.
He's been released as a witness. He can absolutely remain in the courtroom for the rest of the proceedings. The rest of the proceedings are gonna be the state's doctor when we come back. I told the jury 1 o'clock, it's 12:06 now, so that gives the attorneys and court personnel at least 45 minutes or so for a lunch break.
Thank you, Judge.
You're welcome.
You need me? I trust your boss. You want him to go eat, or you want him to hang out, or you want to talk to him about anything? It's a good disposal to have. He's a picky eater, you know, eating's not his forte. Oh, sorry.